Good afternoon. My name is Keith Findley. I'm a clinical professor of law at the University of Wisconsin Law School. I'm also president of the Innocence Network, which is an association of 61 innocence projects around the world, including 52 in the United States. Collectively, the member projects that make up the Innocence Network receive literally thousands of requests each year from people in prison claiming to be innocent of crimes they did not commit and requesting for assistance in proving their innocence. Resources are limited, though, so our member projects can only take a very small percentage of those cases. Nonetheless, in this case, the Innocence Network as a whole, through its board of directors, has voted to become involved in this case on behalf of Mr. Keith. And we did so because this case is so troubling. It presents the darkest scenario possible for our criminal justice system: the execution of a man that compelling evidence suggests might be innocent. Through our work exonerating the innocent over the past decade and a half or so, we've learned a tremendous amount about wrongful convictions and the causes that put innocent people behind bars or on death row. One of the things we've learned is that a very common theme running throughout virtually every one of these wrongful convictions is that of tunnel vision. Tunnel vision is produced by natural cognitive errors that we're all susceptible to, as well as institutional pressures and default rules in the criminal justice system. Tunnel vision affects even the most well-meaning actors in the criminal justice system. Tunnel vision leads people to reach a conclusion of guilt early in the process, and then to stubbornly cling to that conclusion, to filter all subsequent evidence obtained in the case by the lens provided by that judgment, so that all evidence tending to incriminate the suspect is viewed as significant, highly relevant, very probative, very reliable, and all evidence tending to suggest the person is not innocent, is not guilty, is disregarded, is irrelevant, unreliable, the product of a not very good witness, whatever it may be. This case involving Kevin Keith reveals troubling signs of tunnel vision at work. We have an early determination of guilt. Within 42 hours after the crime, police made their caller and trumpeted their success in catching the killer. And then after that, the indicators are there that the state went about interpreting all evidence in the light most incriminating against Mr. Keith and ignoring or discrediting all of the substantial contrary evidence. We've heard talk about the eyewitness identification evidence, for example. We know that eyewitness identification error is by far the leading cause of wrongful convictions, and we know that eyewitnesses are notoriously unreliable. In this case, we know that the conditions under which this identification were made bear all the hallmarks of an unreliable identification. Nonetheless, this tunnel vision process led state actors to put tremendous faith in the eyewitness identification while completely ignoring the contrary eyewitness identification evidence, excluding Mr. Keith as the perpetrator of this crime. This tunnel vision has also led state actors to ignore the compelling evidence of another man's possible guilt that has emerged in recent years, and that was in fact not just ignored, but suppressed by the state. And that process of tunnel vision has led the state to simply disregard, utterly ignore, the 4 alibi witnesses who placed Mr. Keith at a very different place than the site of this crime at the time that it was committed. Given all of these concerns, we, the Innocence Network, ask Governor Strickland to follow the prudent course in this case, grant clemency to Kevin Keith to avoid the unacceptably high risk that an innocent man may be put to death. Thank you.